Hello, everybody. Welcome to another episode of The Dissection. And in the lab today, we're going to be looking at Siphithiphithi Reloaded. Remember Yizo Yizo? Remember Yizo Yizo the return, Papa. Yo, Siphithiphithi the return. That's where we are right now. Siphithiphithi buyile, boy. And just a few days after the conclusion of the election, and one day after the announcement of the results, we are back in this pity in a big way. So today we're going to be talking about three things. In part one, we're going to be talking about Judas Kumalo. Part one, we're going to be talking about Judas Kumalo Chugela. Judas Kumalo Chugela. And we're going to be palapalistically dissecting all of the events that played out today, because Judas Kumalo was at the electoral court saying that he wanted to be reappointed as the leader of Umkhonto weSizwe party. So we're going to talk about that. Then we're going to talk about Zuma's responses outside and the political statements that he made there, and one of the theories that Umkhonto weSizwe wants to try out in parliament to try to kind of like hold everybody by the gonads, if you will. And number three, we're going to look at the actual court arguments that were made inside the courts and the prospects of success. So a variety of things were happening, and it was Siphithiphithi with some chakalaka, and then some chakalaka, not chakalaka. What is chakalaka? I don't know. I'm getting carried away. Right. So here's what happened. Judas Kumalo, he came out of the courtroom, and Umkhonto weSizwe people ran to him as their leader. They were running to him, and he dashed into his car. He's got this big car, Land Cruiser, black Land Cruiser, Toyota Land Cruiser, and apparently it's worth over 2 million rands. And right next to him, there was a Mercedes-Benz truck with his security guards. So it seems as if he didn't want to speak to his voters, his supporters, as the leader of the party, that he had somewhere to be. Maybe a farm, maybe a house of looting somewhere close by. But in any case, he wasn't available. So he jumped into the car and he dashed off. What this indicated is that he actually is afraid of his constituency, the members of Umkhonto weSizwe, and that he has a resistance and a reluctance to speak to them, because many of them actually view him in the manner that I described him, as Judas Kumalo, not as Jabulani Khumalo. And I think Judas is a fitting name, because he did actually like sell out the very people that he was working with and who he was in cahoots with to bring this party into fruition. The question I have is, even if he were to win, how would he actually execute leadership of the party with no credibility? How would he be able to go to Mpumalanga, KwaZulu-Natal, even Gauteng, and speak to the constituency of MK? How would he be able to do constituency work? He wouldn't be, because a lot of people view what he has done as being something that was an act of betrayal and that he may have taken money. I don't know. I can't answer that. But people are saying that he has very expensive cars now, and bayabuza ukuthi uyithatha le mali, which is to say, where do you get that money from? Tell me where you got that money from. Tell me where you got that money from. I got it from my mama. I got it from my lume. I got it from I didn't say anything. Right. So I want to actually tell you what this is all about in real terms, and let me stop joking around. So in Zimbabwe last year, there was an election, and this election was between ZANU-PF and the Citizens Coalition for Change. The Citizens Coalition for Change was led by a man called Nelson Chamisa. They actually got 40-something% of the vote. ZANU-PF also got, I think, 50 or something, just above 50, and they won the election. So in this particular scenario, CCC had many seats in parliament. So they went and they swore in, and they were about to do the business of parliament. And they were actually happy, because they had prevented ZANU-PF from getting a 2/3 majority. What then happened is a gentleman emerged. His name is Sengezo Chabango, I think. And he said, actually, I'm the Secretary General of the party, and I'm going to recall certain individuals from various constituencies. And people said, no, we don't know you. You're not the Secretary General of the party. You don't have mandate from leadership. Then he went to the courts against the CCC, and in Zimbabwe the courts generally do work in favor of ZANU-PF and not necessarily principles of law. So the court said, hey, he's the Secretary General, he's entitled to recall these people. He recalled those people. There was a by-election. The ZANU-PF won those seats. And then they were able to get a 2/3 majority, which allowed them to extend the term of office for Emmerson Mnangagwa, who many people view as being a dictator, and many people say was implicated in a genocide in the 1980s where over 30,000 Ndebelés were killed. So this is where this strategy actually is coming from. And this is what the end game is with this strategy. And if you remember, ZANU-PF was invited to South Africa by certain individuals, and it seems as if this is where the idea was planted. And this is what this game is about. Will it succeed? I'm not sure. Let's go now and see what Jacob Zuma said. And I'll translate this, but we'll listen to him first, and then I'll translate and give a truncated version for those of you who are not familiar with Zulu. When I get some little bit of guap, maybe I'll be able to do subtitles. But right now, just doing this for the love, baby. Right, let's go. Let's see what Zuma said.
And uma ngoba sibakhuzile bangakhuzeka uma beye parliament sibaningi kabi umkhonto wesizwe yebo baba singase sidube ukuya parliament singase sidube ukuya eparliament akekho kuyothatha itulo zethu lapha yithe siye parliament yebo kodwa asifuni ukuya singaphelele ngoba sirojiwe.
So what he's saying is that they may not actually go to parliament because they've been robbed, and they may not have the enthusiasm to go to parliament. And what he was referring to here is a provision of the Constitution which speaks to composition of the National Assembly, and this is Section 46. So Section 46(1) says that the National Assembly consists of no fewer than 350 men and women as elected members. The MK party has 58 seats. So if they do not go to parliament or to the first sitting, the constituting sitting, that therefore means that the National Assembly does not have 350 members. And then the constitutional question is, can they constitute without the 350 members? Because in order for them to even start the business of parliament, they have to actually constitute. So this is what the legal theory is by the Umkhonto weSizwe Party, is that they can actually use as a negotiating tool the fact that they may not be a parliament if they don't show up because they've got 58 seats. As to whether or not this is a viable and successful legal theory, right, there is a counter-argument that has been made, and the counter-argument is based on the rules of the National Assembly. The rules of the National Assembly stipulate the following. In Section 36, they deal with how many days members may be absent for, in consecutive days that they may be absent for, and that's 15. And then if you're absent for longer than 15 days, you have to get permission from the House through a motion. And if there's no motion granted, Section 37 deals with the consequences of that, and it says a member who absents himself or herself for 15 or more consecutive days without authorization loses membership as per Section 47(3)(b) of the Constitution. So this is what is being alluded to here, and part of what is the legal strategy of the Zuma camp to try to negotiate for better conditions. Remember, they said that they wanted a recount, then they also said they wanted a revote at a particular point because they were concerned about irregularities that they allege in KZN. I have not been able to confirm materiality of those irregularities, and therefore I cannot endorse any of the statements that have been made. That is subject to change, but as things stand right now, all of the evidence that I have looked at and on social media and everything does not indicate to me that there was a material, breaking of electoral rules or manipulation of data to actually give credence to the arguments that are being made by Umkhonto weSizwe. So as I said in my last video, I think that the elections were free and fair, and as a law graduate, I cannot in good conscience say that I can endorse or support the idea that is being purported without actually seeing stronger and better evidence. So having said that, that is what the strategy is. Will this work? For instance, if you try to implement Section 37, I think that there would be some issues from expelling people and saying that a whole political party that got over 2 million votes can't come to parliament, and this could get repeated and repeated. I think that it begins to speak to the fabric of democracy, and that everyone has to be very careful about trying to use these rules in ways that undermine even the will of the people who voted. So politicians will play games, but at a deeper level, we need to remember that democracy is about those who govern doing so with the consent of the governed. If the governed have given a mandate to a particular group and rules are used to exclude that particular group, we have to ask ourselves, does that not undercut the principles of democracy in and of itself? So that's really something that's a challenge here that everybody has to think very carefully about. Sometimes people get hard-headed and then end up going into games of confrontation that actually erode and corrode the very institutions that they thought they were preserving by being confrontational and arrogant in the first place. So I think everyone has to really think about this more thoroughly than what everyone is thinking about it now. Because I think in one instance, even if they were to lose this, it could hurt the credibility of the institution. Also, if this goes to a constitutional court, based on how the Constitutional Court has been ruling against Jacob Zuma, I think that they may take an interpretation which favors this particular second argument, the rebuttal, as opposed to the first argument, just based on the way things are viewed there and the way judges feel sometimes about Jacob Zuma. Right. So then he went on to talk about, Judas Kumalo Chugela, and this is what he said.
Ngambona eselahleka nje ahlala lahleka. Awuphile insizwe. Kanti uye wahlangana nabantu nabanye abantu bakagogo engezukubiza umuntu ngagama, angizukubiza nendawo. Bathi kuye, wena ubhalisele nto? Wathi yebo. Eyakho mosi makunjalo, wena ubhalisile. Kusho ezinye igebengu engizaziyo. Zazi ngosini. Zamnika imali. Hayi imali encane. Sendampa. Hayi imali encane. Yazi ngisho imali yokuqala abamnika yona. Ilokhuzana konje ngisimawuthi. Angisazi phela isingisi bakwethu. Ilapsam. Ubani wazi isiZulu? Ubani wazi isiZulu? Isigidi niyazi manje kuthiwa isigidi. Ngesingisi kuthiwa? Nazoke. Inobani 00. Bamenzela yonke inhlobo yento enhle. Uyabona ke? Nakishe emzabalazweni babe khona abantu abadayisayo, abathengisayo, abathengwayo. Akuyona into engajwayelekile leyo. Wayesethi ke hayi organization yakhe le.
So into azama ukuyisho lapha ukuthi lo baba lo uJudas Kumalo Chugela wayithengisa wahamba endaweni eplazini kwelinye indawo. Oh man, I'm supposed to be translating. I'm just playing with you. What he's saying, that he started seeing that Judas wasn't showing up a lot of places, and then he found out that he went somewhere, met with some people, and they told him, "Hey, did you get this thing signed? Is this your thing?" And then they said, "Hey, this is your thing." And then apparently he was then given a significant amount of money. And according to the allegation made here by former President Zuma, is that he got even a lump sum of $1 million, and all manner of things were done for him. Perhaps fancy cars being bought for him, security, perhaps even paying for his legal representation to go to the courts to actually try to undermine the current leadership of MK. This is what he's saying and alleging. And then he's also saying that, even in the struggle, there were people who would at different times actually sell out and facilitate help for the apartheid regime in Mpimpi, basically. And there are many people who've been accused of this thing. I can't speak to it. I don't know whether those things are true or not. Botera Likota and others have made allegations, wild allegations, about a variety of people having this particular label of having sold out or acquired riches fastly and unjustly. But I can't speak to it. I don't know anything about that, right? So now, this kind of different approach, if you think about it, Zuma is embraced by the crowd. Judas is chased by the crowd. It just shows you that it's very clear to the people of South Africa who is the leader of Umkhonto we Sizwe party. And I think that those who are playing this game should really reconsider, because to continue to pursue these underhanded tactics and tricks does lead credence to his argument that people are trying to, by any means necessary, remove him from the equation. Those who are doing so may think that they're doing so for just reasons, and that, they are justified because this is not a good man or whatever they believe. But to many people, they're going to look at that and look at it as a persecution of their former president and somebody that they just gave a mandate to lead a new political party. And people sometimes are not reflective of how they help other leaders gain support. And it can be as a result of underhanded tactics and people then viewing the second leader as being somebody who is being scapegoated, targeted, and actually being attacked unjustly, whereas people who have done similar things are actually pretending to be holy, while actually they also have been implicated in various things and their family members have benefited maybe from IPP contracts or other things. People can see these things and it can make them hesitant to embrace particular narratives. So I think there's a need for some reconsideration. I think if people don't want to negotiate with this party MK, that's justified. If people are concerned about the MK and its anti-democratic rhetoric, that is justified. We should all conversate within a framework where we value democracy, we value tolerance, and we value peace and stability. But these underhanded tactics do not advance credibility for the side that does these kind of things. And I think it's worth considering for everybody. Now, let's go to the actual court, the court process in and of itself, right? And pay attention to all of the things that happen there.
By handwriting, I mean in the sense of DT authored the letter himself. Our submission is there is enough evidence on the papers to suggest that Ms. Duduzile Zuma Sambula authored that letter without authorization of my client. We will persuade you using the papers as to why you must agree with us on that score. If you agree with us on that score alone, independent of the first round of attack which I've narrated to this court, Mr. Khumalo must again come right. In the alternative, you could view both arguments in conjunction and then make your conclusion. Ultimately, what my client seeks is to be reinstated as a party president, directing IEC to reinstate him as a party president. Having made those submissions, then I will rebut the arguments that are raised in the answering affidavit, as well as the heads of argument on behalf of the third and the fourth respondent. Now I start with the first attack, which is directed at the IEC in regards to Regulation 9 and our submission that they did not comply with Regulation 9. What is common cause, and I'll not take the court there. To an extent, you want me to take you to a particular paragraph, particular page, please direct me, but I work on the premise that the court would have seen the entirety of the papers. What is common cause is that Mr. Khumalo, in his name, registered Umkhonto we Sizwe. There seems to be no dispute there. In his application to register Umkhonto we Sizwe, there is an annexure called Annexure 1 in terms of the regulations. It provides for details of who the party leader is. There Mr. Khumalo's name appears. Elsewhere in the same annexure are details of the contact person for the party. There again, Mr. Khumalo's name appears. The IEC then responds to this application, confirming that MK has been duly registered, with those details being accepted as the registered details of the political party. I make this point because in the answering affidavit, there's a claim that Mr. Khumalo has never been the president of MK. We submit that is, of course, misguided on the basis of Annexure 1. The real dispute then is whether Mr. Khumalo was properly removed as the party president. Of relevance is Regulation 9, and I beg your pardon, I must read the provision, it's not too long. It's Regulation 9 to the Registration of Political Parties Regulations. It says any change in the particulars furnished in Annexure 1 that I've made reference to must be notified to the Chief Electoral Officer in writing within 30 days after such change by the registered leader of the party. And that's where it leaves it. What I must bring to this court's attention is the older iteration of this provision, which provided that it's the party leader or any other authorized person who may effect such a change. That has been amended in 2021 to do away with any authorized person. That is key, as I'll submit shortly. Suffice for the moment to make the point that on the cold reading of Regulation 9, only Mr. Khumalo could have effected that change. Not anyone, certainly not Ms. Zuma Sambula. What you would have seen in the IEC papers is, for the first time, evidence of who sent that email purporting to be Mr. Khumalo's letter, the impugned letter that we argue there is enough evidence to say it was forged by Ms. Zuma Sambutla. In that email, you can see that Ms. Sambutla herself sent that email to IEC, not Mr. Khumalo. What is interesting is that in all the communications between MK Party and IEC, Mr. Khumalo was always copied. For some reason, when Ms. Zuma Sambutla sends this email purporting to be Mr. Khumalo's email, Mr. Khumalo is omitted from the parties copied in the email.
I just want to start here by almost apologizing to be here with such a matter, which is a waste of the court's time. And that's why I wanted to say that it's unfortunate and embarrassing that this court has to convene on an urgent basis for matters that less unsubstantiated and false so-called evidence, and at best an abuse of the court's process. And I will address that when I talk about costs at the end. But essentially, what we are here for is a concoction of demonstrable lies by Mr. Khumalo, made up stories, defamation of character of, in particular, former President Zuma, Ms. Zuma Sambutla, and the people who used to be in the interim leadership corps or national leadership corps with him. And we will show this court blow by blow where those untruths are. And we will submit that even with the half an hour of evidence from the bar that we received this morning, and my learned friend was saying I should object, well, there's nothing to object to, because if he didn't give evidence from the bar, he would have nothing to say. He was now turning into a handwriting expert, and look at this comma and that comma there, and even taking instructions from Ms. Junior for more evidence from the bar. Now, the issues in this matter are quite simple on the merits. The first issue is the alleged basis of this application, which is the doctrine of ultra-virus. So if you look at paragraph 2, or prayer 2, it says the first respondent's decision to remove the applicant as the president of the third respondent and party leader of the third respondent is declared ultra-virus. Well, my learned friend, Ms. May, has demonstrated that for starters, there's no reviewable decision. But for my purposes, as the person arguing the merits, let's assume that the so-called, so when I do this every time I say decision, it is to indicate that actually there isn't a decision. There's a litany of cases which show that if when you do a so-called clerical exercise, it's not a decision in the admin law sense, whether paja or legality. It's not a decision. But as I say, for my purposes, for now, we assume that there was a reviewable decision. But on what basis is it being reviewed? On the basis of ultra-virus. Now, that is either a complete misunderstanding of what ultra-virus means, or something else, or there's no cause of action. Ultra-virus is just fancy Latin, which means that it's outside of the powers. Ultra, outside, virus, powers, outside of your authority. In other words, what they're saying is that the IEC acted outside of its powers when it responded to the instruction from the letter. Now, there's nothing that could be further from the truth. You could say the IEC exercises powers improperly and so on, but you can't say it didn't have the powers. Regulation 9, which he read, says exactly that the IEC does have the power if it's instructed by the party leader, with which we will go into now. So this case has got nothing to do with ultra-virus. It's just badly pleaded. But let's take it from as it comes. So that's the first point. If you get that aside, then we don't even have to go any further. And then, of course, prayer 3 is even worse. My learned friend, Ms. May, tackled it from the point of view of jurisdiction. But on the merits, we have to look at it from the point of view of actually what it purports to do. What it purports to do is to be a substitution order. In other words, if you do review and set aside the so-called decision, then what they're saying is that you must not refer it back to the IEC. You, as the court, must now reinstate and override the IEC or exercise the powers of the IEC. Now, that's not done. Everyone knows that. The IEC is a specialist body which has the powers to do all these things. The court is not such a specialist body. And the court only does substitution under so-called exceptional circumstances. When A, the decision would be a fait accompli. B, there is bias on the part of the decision maker. And the case, which is well known, I'm not even going to bother the court, it's called the Trencon. The Trencon case gives us the requirements for substitution. I'll get the citation. It's a 2015, I think 2015-5 decision of the Constitutional Court. Sorry, just bear with me. Yeah, it's 2015, volume 5, SA, page 245, CC, Constitutional Court decision. The judgment of Her Ladyship Justice Khampepe. Sorry, just a minute. And it lists the following factors. A, the court is well qualified as the original authority to make the decision. B, the end result is a foregone conclusion. C, further delay would cause unjust prejudice. And D, the original decision maker has exhibited bias or incompetence. Now, none of that.
Where were you reading from?
From the Hoekstra on admin law. It's page Hoekstra Administrative Law in South Africa, the 3rd edition, my lady. And the requirements are listed from page 790. 790, the latest edition. Now, so this court is now being asked to do a substitution without any of those requirements being pleaded. No allegation in that regard. So apart from the issue of jurisdiction, even if we assume generously that the decision is reviewable and can be set aside, this court cannot reinstate Mr. Khumalo. And that is because, and again, I'll revert to so that I don't waste time, to Ms. May's submissions for a different purpose. That is because Mr. Khumalo and his team are missing the most crucial point. Again, this is a manifestation of the so-called Odekral rule. You cannot come to this court to say that the leadership dispute must be resolved in my favor, and therefore all these things then we'll review and set aside. In other words, until this is what is called a collateral challenge. So until the decision to remove him as a leader is reversed, you can't move. Because the decision to remove him, according to the case of February that my learned friend read, is the so-called factional dispute, leadership dispute, and so on. That dispute belongs to section 20, like a 2 big A. And you can do two things with a decision like that. You either come to this court in terms of 20 bracket 2A, or you go to the High Court on the basis of the common law, contractual, the usual political party disputes. So if you're going to come under Section 19, or if you're basing your cause of action purely under Section 19, you can come here. So it's the so-called concurrent jurisdiction. But if you're basing your case under the common law, the contractual relationship that was set out in Ramakata, then you can go to the High Court. It's simple. It just depends on how you plead it. Just like a labor matter. If you are going to rely on the LRA, you go to the labor court. But if your dispute is a contractual one between you and the employer, then of course you can come here. That's all. So they haven't done either one of those. So that decision must be regarded as valid until it's set aside by a competent court of law. And we know all the philosophical reasons for that. It's for certainty. The law would be chaotic, so to speak.
At the end of the day, this is what I think about this particular case. I don't think that the applicant here, Mr. Judas Kumalo Chugela, has actually got a strong case. I actually think that I'm more persuaded by the arguments that were made by Advocate Dalimpofu in this particular case. I do think that this is spurious. I think that it's wasteful. I think that he's taking a chance. I think that he has been contradictory. I think that he has not proven himself to be a credible witness. I think that a lot of the allegations that he made were not in the legal standard of acceptable evidence. And as such, I don't think that the Electoral Court will deviate from all of the standing rules of evidence and all of the case law that was argued in this particular case today to rule in his favor. So I think they'll lose this case, but you know, I always leave room for surprise. I could always be surprised, but in this case, I don't think that I will. Right, so that deals with the Siphithiphithi of MK. Today we also got like an announcement from Gayton McKenzie that the Patriotic Alliance is entering into negotiations with the ANC to see what can be done. We've heard from Gayton McKenzie saying that he wants to have the Ministry of Home Affairs because he believes that he can do a better job. People who are critical of that have said that, you know, Home Affairs doesn't just deal with immigration, it deals with birth certificates, death certificates, all manner of documentation. And they don't know whether he has the project management and administrative acumen to be able to provide the managerial leadership that is necessary for this particular ministry. But he has said he does, and he has said that he has strong views, and as we know, he wants to facilitate mass deportation. From a legal perspective, I can tell you right now for free, mass deportation is not something that is going to be constitutionally possible because it just goes against a lot of international law and domestic law, particularly Refugee Act and Immigration Act in and of itself. Unless those acts are amended, that could be possible, but it's unlikely that everything will be amended in the way that he wants, because some of those things won't meet the constitutional threshold of the Bill of Rights, and that's something that everyone has to be aware of. It's similar to the argument around death sentence. Any politician who says that they're going to implement the death sentence is misleading people, because the South African Constitutional Court has been very clear about where they stand on that, and you cannot introduce it through a back door. And even if you try to change the relevant sections of the Constitution, you would need a super majority to do it, which any of the political parties in this climate does not have. So the right to life is sacrosanct, and is not going to go away in this particular constitutional dispensation. And that's just the 101, Constitutional Law 101. So the case is, what is it? It's Makwanyane, right? S versus Makwanyane. That's the case if you want to read it and see all of the details and the arguments that were made by the Constitutional Court in that. So that's the last topic. And to land the plane, to close the lab, put the equipment away, I saw some reporting from Times Live about Dudu Zuma and Khumalo, the spokesperson of the MK party, and they were talking about whether or not these people are in a romantic relationship. And I want to say that I view that to be a form of gutter journalism, a form of journalism that is an ad hominem attack. An ad hominem is an attack on the person, where you try to vilify the person, to demonize the person, so that the particular person is not given the status and recognition of any of their work by the public. It's not a reasonable argument, and also a way of argument. It's a fallacy, and it's something that we try to call out. It's like a red card of logic, right? And this is what I think this is. But further, I think that this damages the media at a critical time. The media is saying that they are concerned about democratic norms. Part of democratic norms is having a media which is balanced, which is well-researched, which is fact-based, and which does not play agenda politics for particular factions within the estate. So when the Fourth Estate starts playing as a player on the pitch, that in and of itself undermines democracy, and it also undermines their credibility for the times when they want to make serious statements. Because if we come to the newspapers and the websites and we find that you're talking about bedroom politics of a woman and trying to villainize her, when that same treatment is not given to other politicians of the same stature or even higher stature, we've heard so many allegations of people in the confectionery business, chocolate muffins, cupcakes, and all kinds of things that they sell there, bread, brown bread, Albany, what I'm saying, scones. So we've heard all kinds of rumors, but these things have never been traversed by the media, and it's correct. It's correct. We don't want to hear what chocolate muffin did to the scone. We don't want to hear what butter and jam were used to spread those two, delectable confectionaries. We don't want to hear any of that. We really don't. And it's gutter journalism to do this. It hurts the media, it hurts its credibility, and also it is a form of undermining the democracy that they say that they are trying to protect and to provide the public with information of. The last one is, I also saw senior journalists saying that particular political parties should not be given platform. I think that too is anti-democratic. The people of South Africa have given political parties mandates. And when those political parties speak on issues of national interest, issues which affect parliament, issues which affect the constitution, the administration, issues which affect the national affairs, the public has a right to know what those people think. You can bring in analysts to fact check them. You can bring in analysts to correct any of the things and speak after they've spoken if you want to. But to take a blanket approach, say every time these particular people speak, we will not give them a platform, I think that goes against the principles of journalism, and I think it's something that should not be embraced in the name of defending democracy. I think a lot of things, wrong things, can be done in the name of something good, and we often have to be careful about normalizing those behaviors, because those behaviors can end up having the unintended consequence of fast forwarding or accelerating the very thing that they were supposed to prevent, right? So that's my thinking around that. Well, guys, I'm out of time for today. It's been a great show. I'm so happy that you've watched till the end. Thank you so much. I'm curious, what do you think about Judas Kumalo Chugela? What do you think about the statements made by Zuma? What do you think about the strategy of doing this Section 46 no-show type of thing as a form of negotiation? What do you think about Gates and talking to the ANC, trying to get that Ministry of Home Affairs? What do you think about how the journalists are covering certain things around Dudu and Klamulo? What do you think about the no platforming of particular parties and individuals in the name of defending democracy? What do you think about the court arguments made by Advocate Dalimpofu SC today and Counsel for Umkhonto Wesizwe? Let's have a conversation. You know, it's Siphithiphithi season. It's back, this thing. It's back. So the lab will be open. We'll be dissecting all the time, every time. If you like this content, double tap. Is it double tap? Just like, comment, subscribe, put on the notification. But let's grow this thing. Let's grow this thing. If you like this show, tell other people. Check out MJTV on the thing. Check it out. Peace.